Hello, my name is David Petrosky. I'm an attorney in California representing landlords on eviction cases. Today I'm going to be discussing the tenant's duty to maintain the property. This is codified in California Civil Code section 1941.2. First, I'd like to tell you a little bit about myself. I run a 5-star law firm. I've been representing landlords in California since 2004. I'm a published author and a great referral source for real estate agents, landlords, and other attorneys. Plus, we get results. Here, you'll see a judgment where we received possession of the property, plus a money judgment of $9,690.97 for our landlord client. Of course, there's no guarantee of success in any given case. Today's presentation is going to be divided up into 3 sections. I will first discuss the purpose of the code section, followed by an outline of the code section itself, and I will then offer some guidance and best practices for landlords. So let's dive right in and talk about the purpose of California Civil Code 1941.2, the tenant's duty to maintain the property. Oftentimes, landlords will use this code section to counter the breach of warranty of habitability affirmative defense that many tenants will raise in an eviction case. Civil Code 1941.2 lists certain requirements that a tenant must do at the rental property. It's not just the landlord's duty to maintain the habitability of the property, which is often what tenants will say, but it is also the tenant's affirmative responsibility to do certain things at the property. And if the tenant doesn't do some of these things or allows certain things to happen that breaches Civil Code 1941.2, then the landlord will use that as a defense and as a counter to any breach of habitability claim that the tenant makes. If the tenant does not do what is outlined in Civil Code 1941.2, then oftentimes the landlord does not have a duty to repair any fault that the tenant created. Landlords should use this section to combat any tenant claims of habitability breaches. Here you're going to see the actual code section for Civil Code 1941.2, and it's a lot of information, and I apologize in advance for that, but I wanted to list out the entire code section here so that you can read it. You may want to pause the video for a minute so that you can read through each of these bullet points in detail. I'm only going to highlight some of the main parts right now in this presentation, but if you look here in section A, it talks about having no duty on the part of the landlord to repair conditions of the property if the tenant is in substantial violation of this section. And you want to make a note of that because that is a key word, substantial violation. Or if the tenant is interfering substantially with the landlord's obligation under section 1941, which talks about habitability. So again, that keyword, substantial. What is substantial? Well, that's debatable. And you would want to make an argument on what is or is not substantial. Section 1 here says that the tenant must maintain the property in a clean and sanitary condition. The tenant must dispose from the unit of any garbage and other waste in a clean and sanitary manner. This is another key word, clean and sanitary. Part 3, the tenant must properly use and operate all electrical, gas, and plumbing and keep them, here it is again, clean and sanitary. Section 4, the tenant is not allowed to permit any person on the premises with permission to destroy, deface, or damage any part of the dwelling unit. And the tenant must occupy the premises as a residential unit using it for its intended purposes only. And if the tenant is found to be in breach of any of these provisions outlined in Civil Code 1941.2, then that absolves the landlord of liability. At least that's the argument that the landlord would make if the tenant claims that the landlord has breached the warranty of habitability. Now, in terms of some guidance, you will want to actually read Civil Code 1941.2. I outlined it above. You can pause the video there and read through it again. You can also do an online search for Civil Code 1941.2. One of the questions that you and the tenant and the court is going to be asking is whether the tenant actions or inaction is a substantial violation. So you're going to have to make that argument of the tenant's action being substantial. How are you going to do that? You're going to gather as much evidence and proof as you can. Any witnesses, any pictures, any written documentation to support your claim will be helpful, and you're going to want to be able to show that it is a substantial violation. You also want to read through Civil Code 1929, and it's very short and simple, and it says that the hire of a thing must repair all deteriorations or injuries thereto occasioned by his want of ordinary care. Well, in regular English, that means that a tenant is responsible for repairing any damages caused by the tenant. In terms of additional resources, my website, which is attorneydavid.com, offers many forms available for download, several of which are free and available immediately if you go onto the website attorneydavid.com. I also publish a blog regularly with a lot of helpful information for landlords, which includes best practices and what a landlord should and should not do with respect to renting property. I've also written an article that specifically addresses Civil Code 1941.2. If you are in one of our service areas of where we handle eviction cases for landlords, feel free to reach out to us either by phone or on the website. Both our phone number and our website is right here on the screen. If you look on the bottom, you'll see our phone number and our website. You can reach out to us, and we will provide you with a free consultation if you are a landlord in our service area. Finally, I would encourage you to subscribe to our YouTube channel. I will post videos that are discussing landlord, tenant, and best practices. And in addition to that, you should like us on Facebook, follow us on Twitter. You will see lots of helpful information for landlords, and in particular relating to landlord-tenant relationships and evictions. Thank you very much. Have a wonderful day.